Hmm? Okay, when doing this, I ain't going to court.
Make sure you got every complaint right. They have the first license for your bill, you say the other one, which is the first license for stuff for your bill. And the way they have their set up, you can see the board members, but you could not see or hear any of the applicants for APU representation until they.
Okay, why don't we get started? I don't think, Mr. Forte, you need to take anything down yet. I'll let you know if for this proceeding, the Marrero proceeding, you need to take anything down. Before we dive into that though,
Cherokee County.
second item on the
Tested positive.
is that gonna be a plea?
They say, what they said, they had
Hold on one second.
15 minutes.
I couldn't hear you, Your Honor.
Sorry, I just muted Mr. Sims. He was.
Oh,
Can you hear me now?
I can.
Okay, the second position, DeMarcus Simmons or Simons, is that a plea?
Yes, Your Honor, that's a negotiated plea.
Okay, great. And is that with a private attorney?
Yes, that is with Mr. Lancaster, I believe.
Okay, great. All right, let's talk about Mr. Marrero then. He's not here. He got notice to be here. He also missed another court date. We're here not so much to talk about why Mr. Marrero is missing as we are about representation for Mr. Marrero. There was some funny business that I don't think involves Mr. Sims. I'm not suggesting there was any issue with Mr. Sims, but there's a woman out there masquerading as an attorney who is not. And I look forward to hearing from Mr. Sims about his connection with her and what he thinks happened in this case. Mr. Sims, can you hear me? So you're on mute right now. You may need to get someone to unmute it at your end. There we go. How are you doing today, Mr. Sims?
I'm doing great, Your Honor. Can we turn it up a little bit, the volume? Okay.
I appreciate you dialing in. I know these are complicated times, but we are trying to sort out what's going on in Mr. Marrero's case. Did you ever figure out who Wanda Cooper is?
I know Wanda Cooper.
Okay, how do you know Wanda Cooper?
She's associated with my office. She helps me with some tasks, administrative type things.
Okay. So why would she have said that Mr. Marrero had retained you?
What I'm thinking is he was supposed to come in and make payments to the office to retain us. And we had some promises, but we have not seen him and he's not come in. Okay,
so Mr. Marrero has never paid you or followed up on what he's supposed to follow up on?
Best of my knowledge at this time, I've not had any additional contact with him. And we gave him the fee and I've not received anything from him.
Okay. I'm just reading over your motion here. So you're not holding money of his that you need to return. He's actually never given you any money.
He's never given me any money. I have nothing to return to him, y'all.
Okay. And did you ever meet with him or would he have met with Miss Cooper?
He contacted me through Miss Cooper.
Okay. All right. Then I don't see a reason why we should not release you from this case. We'll need to track Mr. Marrero down and figure out what it is he wants to do. Ms. Hall, is there anything you want to add?
No, Your Honor.
Okay, so Mr. Sims, again, I appreciate you taking time out of your day. This one's been a confusing one. I do want to pass on a message to Ms. Cooper. She needs to be very careful how she represents herself. I think she has held herself out to be counsel, and she may well be associated with you, but our review suggests she's not an attorney. And so she just needs to be thoughtful about how she describes what her role might be for your potential clients. You would be the lawyer. She might help you out, but of course she wouldn't play your role. And I would just hate for her to get sideways with any authority, and I wouldn't want that to reflect poorly on you if she made a bad decision. Can you make sure you let her know she just needs to be a little more careful about how she describes her role?
I will definitely make sure of that, Your Honor.
Excellent. I appreciate
And
it. And anything else you want to share with me, or are you good to go?
now we've sent our notices to Mr. Marrero at on the Mason Turner address. We've not heard back from him. I don't know if he's a truck driver or what he is, but he's normally, from what I heard from the young lady, he normally appears for court.
He had been to court many times. He missed the last court date. He did provide us with a new address that really is only a couple weeks old, so it ought to be a good address.
Was that Mason Turner, Your Honor, or is that another address?
Mason Turner is what you have. So
I have 909 Mason Turner.
yes, sir, that's what we've got. So we'll take it from here. I will enter an order that allows you to withdraw. So hopefully you won't get any more notices about this case. If you do,
All right, John.
just call Ms. Nelson and she'll excuse you. And hopefully we can get a lawyer on board for Mr. Marrero, and he can move forward with his charges. But I appreciate your time.
Thank you, Your Honor.
Take care.
Yes, sir.
Now it's putting me on the screen. So now it's putting me on the screen.
You guys get us off the meeting. It's okay. It's up there.
I got to leave.
Ms. Hall, is Mr. Simons going to be pleading to the indictment? Are there any changes?
He is going to be pleading partially to the indictment. We're reducing count one, if it's count one on the aggravated battery.
Yeah.
We're reducing it to battery, but the aggravated assault, family violence will remain.
Okay, all right. Well, that's not till 2. So I'm going to go print out the indictment, and then I'll come back out. I'm going to leave the, quite shut down the feed, but I'll stay on the call, and I'll just come back out in about 15 minutes. Ms. Nelson, if Lancaster and his client get on before then, just shoot me an email and I'll come out earlier, okay?
Okay.
Thank you. Yeah, and so you'll hear the conversation of, I need proof that X or Y or Z. So we'll see how this goes. Yeah.
Ms. Nelson,
Yes, yes.
I'm sorry, I got a question.
Mhm.
What are we doing with Moreno? Are we just, is it a bench warrant or are we just gonna reset for whenever he gets an attorney?
I think you should probably, well, I would say it's a bench warrant. You can ask the judge when he comes back on the bench, but he got, let's see, wait, hold on a second. He's instant messaging me now.
Okay,
Yeah, yeah, we can do a bench warrant on him.
okay. Thank you.
Uh-huh.
Are you Ms. Castro Roberts? Do you have, like an EBT card or something that would prove, the information in your affidavit?
I know, I actually was in a homeless shelter in the room with my aunt filed for EBT, and actually they sent me everything, the voters, Medicaid stuff, but they never confirmed me. I
Okay,
think it was the coronavirus thing, I waited out.
sure. I'm sure things are not working real smoothly. Do you have, are you getting unemployment benefits?
No, the only thing I'm getting is a stimulus. I got the stimulus, that's about it.
Okay, and that just goes to anyone who had paid taxes, or have you qualified for that?
Went online, my Cash App told me to go online and fill in information to see if I would get it, and I told him I give this information.
Okay, and you said you're staying, did you say your mom or your aunt?
My
Aunt,
aunt, for that.
okay, and that's where you went from the shelter. What shelter were you at?
I was at Women's Advocate over in Dallas, Georgia,
Okay, how long were you there?
just a day or two, because they have enough room for the three of us. I have another son who's five.
Okay,
Another one, so I just,
where's your other son right now?
he's in the car.
Oh, your aunt's in the car too?
No, my friend is in the car. My friend dropped us off.
Okay,
He was doing it. That was asleep.
all right, let him sleep.
Right.
And what is it, I don't, usually there's some more paperwork.
Yeah, I have all of the 500 years.
What are you trying, you can keep it, what are you trying to do?
This is probably what.
Divorce, okay. All right, so Mr. Wiley is, the respondent. Got it, okay. Were you working before you went to the shelter?
You know, I lost my job the beginning of January last,
Okay,
and I've been doing little side gigs, and I own a cleaning company, so every little dollar I make, I put for the cleaning company.
okay. And how long have you and Mr. Wiley been in different places?
3 years, we're going on 3 years. I just talked to him about, I want to say 8 months ago. I got an email from him, okay, we got an email, but we haven't talked.
Do you think he's in the metro area still?
I want to believe that, but I have no idea. Because I live in Portland, Oregon, he lives in Portland, Oregon, so I honestly don't know where it is. And I
Okay.
called everybody and can't find it.
But you're here, you're in Fulton County.
Yeah.
Okay, all right. So where did you go when you went to the shelter? Where were you coming from?
I had came from, Portland, Oregon, and my in-laws had got me from their apartment. My in-laws came and got me from Kansas City and took me back to Georgia.
Yeah,
So when I got in Georgia, I took me my ex-wife, we were just a few years ago.
yeah,
It didn't work. He ended up leaving his parents' house, I ended up staying there. Over the course of 2 years, I lived with him, stayed with him, we all worked out, but they started doing little things, getting doorknobs off the doors, I'm just, can't do a child on that road. That's when I went to the shelter.
okay, so where you left from was your
That's
in-laws'
when
house?
I in-laws,
Okay,
and that's how I went to the shelter in Dallas, Georgia.
so did you have a cell phone?
I did not, I had gotten a free, I was getting a free cell phone since the shelter told me some about a free phone type of thing, so.
But you don't have one phone number listed on this.
Yeah, that's not honest.
Okay, all right,
I just didn't want to not put one and then you guys need to read it.
right. So you'll need to put the address on here. There's no address on here. It just lists the phone number.
I didn't know what to fill out in front of you guys and.
Well, that's okay. You really should fill it out before you get it notarized. But since I'm asking you to do it, you can do it. And the part I'm supposed to sign, you must have more paperwork. If you just give all your paperwork to the deputy, I'll give this back. You can put the address on there. The thing I sign is yet another piece of paper. If you want to just give me all the forms, I'll find the one. As long as they gave you the whole packet, there should be the one. It's a single piece of paper, and it says, I don't know what it looks like, but it's got a place for my signature that says, there's three, like I grant the waiver, I don't grant it, or I say, there's no basis for your lawsuit anyway. Not your case.
It's not anymore. So this is what it is. So these two are right here. You know what it is? I know you look at all of them. I don't know what that is. Those are pretty good too.
That's the affidavit. This is what you need to put the address on.
Okay. That's what I'm trying to figure out.
That's not it. Lots of sticky notes on it.
Oh, this regular. Mm-hmm. Okay. That's good.
All right, we're gonna get started in 1 minute. We're gonna try one audio change here. We're gonna pull that up. So take.
Can't hear.
Ms. Rolak, are you going to be presenting anything on behalf of the victim in this case?
No, Judge. She sent her restitution information to Ms. Hall.
Okay, so you don't expect anyone to come into court on behalf of the victim?
No, Judge.
Okay. So Mr. Forte, do I mute the computer or the microphone that's up here, or both?
The computer.
All right. Ooh, let's see, that's not good. So,
I can't hear him. I'm sorry, Judge. This is fine here.
how about that? All right.
Perfect.
Lancaster, can you hear me?
I can, Your Honor.
Great. All right, we kicked out that whole other system. It was nice of the IT folks to do it, but I don't think we have anyone coming in. So let me turn it up a little bit. I can hear. Okay. Ms. Hall, good afternoon. Can you hear me?
I can, Your Honor.
All right, is that better than this morning or the same?
Way better.
Way better. All right, so that we know what they need to work on. Let's get on the record. This is case 19 SC 171813. It's State versus DeMarcus. Is it Simons or Simmons?
Simons.
Simons. We've all met before. We had I don't remember if it was a status conference or what, but we are reconvening because Ms. Nelson tells me that Mr. Lancaster, you on behalf of Mr. Simons and Ms. Hall on behalf of the state of Georgia have reached an agreement and that this is a negotiated plea. Is that correct, Mr. Lancaster?
I hope so, Judge. I want to just make sure.
Okay,
I think it is.
Find out. I think, let me put everyone's mind at ease. I just need to look at the file here. All right, so we have not had final plea yet. So what that means, Mr. Lancaster and Mr. Simons, is that I'm going to go forward with the plea. I will hear from Ms. Hall as to what she thinks the right outcome ought to be. I'll hear from you, Mr. Lancaster, and then I'll accept the plea or not accept it. And then I'll let you know what the sentence is going to be. If the sentence that I impose is in any fashion more severe than what you've negotiated, then Mr. Simons will have the opportunity to withdraw his plea if he wants to.
Yes, sir.
It could be more severe because I impose a fine and there's no fine. I could impose more probation if it's just probation. I could impose jail time. But if any of the numbers, it usually comes down to numbers, that I pronounce at the end is a higher number than what you all had negotiated, then I'll give you, Mr. Lancaster, and your client a chance to confer, and then you'll let me know if you want to keep going. And sometimes it is more severe, but it's more severe in this way. You all negotiated, I'm making this up, 40 hours of community service. And I hear of everything and I say, you know what, I think it should be 80. Technically, Mr. Simons could withdraw his plea because I imposed 80 hours of community service instead of 40. He'd be within his right to do that, and we would just move this case towards trial. Usually that's not how it plays out, but he'd have the opportunity to do that. Where it typically falls apart is everyone agrees it ought to be 1 year of jail, and I say, yikes, he tore her eyeball out. I think it should be 5 years in prison.
And what I say goes. But Mr. Simons would have the chance to back out of it either way, whether it's a little bit more community service or all of a sudden the sentence is he goes to prison for 5 years. So I don't want anyone to panic at this point. I'll hear everyone out. If I accept the plea, I'll pronounce sentence. 9 times out of 10, it's exactly what people negotiated. And if it's not, then you'll have a chance to digest it. Does that make sense?
Yes, sir.
Yes, Your Honor.
Great. So the way this is going to work, Mr. Simons, is in just a moment, Ms. Hall is going to put you under oath. You'll have to raise your right hand and swear to tell the truth. Once you've done that, everything you say needs to be truthful and complete. So if you are asked something you don't understand or you're not sure what the answer is and you need a little time to talk with Mr. Lancaster about it, let me know that. That's fine. You guys can take all the time you need and we'll just mute. And then you guys can talk. We can't hear what you're talking about. And then you'll come back on and we'll go forward. There are no trick questions. Nothing is meant to trip you up. So if you're not sure what's being asked of you, clarify it because your answers are being taken down. And like I said, they need to be truthful answers. Will you let me know if you need time with Mr. Lancaster or if you have any questions?
Yes.
Okay. It's also important that when you are answering, you do so audibly. So I saw you nodding your head, which is great. I think I knew what you meant. But Mr. Forte, the court reporter, doesn't take down body language. He will only take down things you say. So if the answer is yes, make sure you say yes loudly and clearly. If it's no, it's no. Whatever your answer is, make sure you say it audibly. And I appreciate you moving closer to the screen there. Mr. Forte will let us know if he can't hear you. We're not going to guess at what you said, but we'll try to get it right from the beginning. Ms. Hall, when you are ready, and by the way, I've got the indictment here. We're proceeding off a copy, so you can ask the appropriate questions about that. But we'll be working off this copy of the indictment. Okay?
Thank you, Your Honor.
Great. And one thing before you start. All right, I'm back. I apologize. I'm presiding this week, so there are people coming and going, and I'm juggling a few things, but we're going to start with Mr. Simons now. So when you are ready, Ms. Hall, let's get Mr. Simons under oath.
Thank you. Mr. Simons, can you please raise your right hand? Thank you. Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Say it loud. I do.
Thank you. You may lower your hand. Please state your true, correct, and legal name.
DeMarcus Jarrell Simons.
And Mr. Simons, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
You take prescription medicine?
No.
Huh?
9 times.
Okay. He has medication for bipolar disorder, but it doesn't affect his ability to understand what's going on.
Okay.
Is that right?
Yes.
Okay.
Thank you, Ms. Lancaster. Mr. Simons, how old are you and how far have you gone in school?
I'm 22 years old and I left school after my junior year of college to pursue a professional career in basketball.
You gotta speak loud.
That's right.
And are you able to read, write, and understand the English language?
Yes.
Your Honor, for the record, the state is amending count 1 of the indictment, aggravated battery, reducing that to battery.
Okay. But count 2 remains as is?
Yes, Your Honor.
Okay.
Well, that was the question because we had talked, Judge, and it's not a family violence ag assault. And it still says family violence, but the offer that we got is not reflective that it's a family violence ag assault. And I say that because the offer was 2 years probation, and if it's family violence, it's got to be at least 3.
Well, I could suspend the 3rd year.
But
My understanding is that Ms. Shank, the connection between Mr. Simons and Ms. Shank would make it family violence and not stranger on stranger. But if you guys need to confer, you're welcome to do that.
no, they never lived together. They were never of the same household.
Okay.
But Ms. Shank actually said they did live together. So we haven't really talked about the family. I never intended to drop the family violence because if they live together, that does make it family violence.
He swears they never lived together, Judge, and that's.
Well, I guess people could have differing views on what live together means. I'm not going to get in the middle of it, but either he's taken an Alford plea to family violence, aggravated assault, or at least it's offered to the element of did we live together? It doesn't sound like he's contesting that he did something he shouldn't have to Ms. Shank. But if there's not a meeting of the minds, then there's not a plea here. So I'm happy to move you guys into a breakout room where you can talk. You tell me how you want to do this.
Well, I just wanted to make sure that I didn't let my client plead guilty to something that he says never happened. Now, he can choose to go forward or not, but I wanted the court to be aware as an officer of the court. I felt like I had a duty to let you know that. And also, we were tendering, it was my understanding that we were tendering a NOLO plea for sake of avoiding any admissions with regard to a civil lawsuit later.
Is that news to you, Ms. Hall?
The reason for the NOLO is news to me, but I did agree to the NOLO, yes.
Okay, so NOLO is NOLO. I mean, he can have whatever reason he wants, but
Right.
you're not opposing a NOLO plea.
Yes,
I
sir.
will.
And of course, it's up to you to accept it. I understand that. But
Okay, all right.
do you want to go
So-
forward?
Yes.
He wants to go forward, Judge.
Okay, let's keep going.
And my lights are literally going off and on, you all. So I apologize in advance if something happens to my internet.
Good
My
luck.
lights twice. Okay, so Mr. Simons, do you understand that you're charged with the following offenses? Aggravated battery being reduced to battery, and aggravated assault, family violence.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney, Mr. Lancaster, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with his services?
Yes.
Counsel, do you waive formal reading of the indictment?
We do.
Do you waive any and all defects in the indictment, including with respect to the defendant's names?
Yes.
Do you waive moving forward on a copy of the indictment?
Yes.
Mr. Simons, have you been arrested on these charges?
Yes.
The state is, excuse me, I'm sorry. The state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
I don't.
Has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes.
The maximum sentence for battery is 12 months to serve. The minimum and maximum for aggravated assault, family violence is 3 to 20 years to serve. Do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of
So Ms. Hall,
I know, Your Honor.
we lost you at that critical time. It was, we recommend a sentence of, and Mr. Simons just about fell off his chair when he couldn't hear whatever it was you were going to say. You're on mute now.
Sorry.
Okay,
Okay. The state recommends for the aggravated assault, family violence, 2 years probation. And I am aware that the family violence carries the 3, but we did negotiate the 2 years probation, Your Honor.
okay,
And the battery, 12 months probation. restitution to be paid to the victim in the amount of $737.17, and a special condition that Mr. Simon speaks to. I may not word this properly, but the intention was for him to speak to college students about his experience in this situation, not necessarily personal details that he was arrested, but how this could affect someone's future.
Okay.
Mr. Simons, do you understand that the court does not have to accept that recommendation? The court can sentence you to the maximum on each of these charges and can run those sentences consecutively or one after another.
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
Have you ever been convicted of a felony?
No.
Well, say no.
No. I don't know if this one.
Have you ever been sentenced for any crime, felony or misdemeanor under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of the first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
It's no law.
It's no law.
Right, but he's still giving up defenses.
Correct.
Yeah.
Okay. You understand that, Mr.
Yeah.
Simon?
Yes, ma'am.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you feel like it's in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by jury at a trial?
Yes.
That's no law.
Yes.
How do you plead to the charges of aggravated assault, family violence, and battery in indictment number 19 SC 171813?
No law. No law.
Nolo contendere.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you, Mr. Simons. Your Honor, the state is unaware of any prior felony convictions by this defendant. And had we proceeded to trial, the state would have proven that on August the 24th, 2019 at 112 Cortlandt Street, Southeast Atlanta, Georgia. I'm sorry. The date is actually September the 14th, Mr. Forte, 2019. But Your Honor, on September the 24th, 2019, Ms. Brooke Shank reported the incident that happened on the 14th to, she went to a police precinct. She stated that she was sitting in the garage, in a parking garage, when she had a dispute with the defendant. They were dating at the time. She said that she tried to break off their relationship, at which point the defendant struck her in the face a few times. She did sustain a black eye, and she needed stitches to her eye, and that's what the restitution amount is for. The money that her parents paid as a deductible when she was seen at Emory Hospital. The investigators investigated this case. They got in contact with the defendant. They confirmed that the defendant was the person, through our victim, of course, that he was the person that hit her that day, and he was ultimately arrested, Your Honor. Our office have been in contact with the victim several times in this case, and the last time we were in court, we were trying to get we were trying to confirm the restitution amount, and that's where we've pretty much been. We've been working out this case for a while now, but the restitution amount was a question the last time we were talking about this case. But that's all from the state, Your Honor.
Okay. I have one question about the date, and then I'll move to other things. The indictment alleges that all this happened on August 24, 2019. That's not a material allegation. That's okay. I just want to make sure we're talking about the same thing.
And I said September, right?
You did, and what you said was September 24th was when she reported it, but it actually was like September 14th. So we had 3 different days, and
right.
It's not hugely important, but I just wanted to make sure the record that Mr. Forte is making reflects whatever you believe to be the day of the actual incident when Mr. Simons did these things to Ms. Shank.
So yes, Your Honor, I apologize for that mistake. I noticed that mistake last time we were in court. I didn't have that updated on my current notes for today. The correct dates were August the 24th of 19. She reported it September 14 of 2019.
Okay. Okay, got it. Thank you.
You're welcome.
Ms. Crawford, I'm not sure if you're able to communicate with us. There you are. Storm is hitting Ms. Crawford as well. She's with Department of Community Supervision. Do you have any adult criminal history for Mr. Simons?
Judge, he has no criminal history.
Okay, great. Mr. Lancaster, what do you want to tell me about the situation?
Well, the indictment, the dates was August 24th to start off with, and so we're in concurrence with that was the date. I have personally known DeMarcus since he was 7. He played on my youth football team. He went to high school with my youngest son. He is probably the best high school basketball player I've ever seen in person. He went on to Georgia State to play basketball. He was the leading scorer in the Sun Belt Conference. He was the freshman of the year for the Sun Belt Conference and had a promising NBA professional career. He left school early to get drafted. He got bad advice. He should have went back for his 4th year. He has a different agent now, I'm told. and then this happened. So I can speak from knowing DeMarcus personally, Judge. He's extremely remorseful about this. A little bit of history about DeMarcus is he has been treated at Renewed Journey Counseling Services, where he was diagnosed with bipolar disorder. and he's currently on medication. And this is from a letter from Sean Allen back in October of 2019, right after this happened. He follows up for medication management, but he's not actively in therapy or counseling. Is that right, DeMarcus? So I also have a letter from Daniel Curtin, who is his agent. He's a client of 3i Agency. And they tell me that he has a high likelihood of employment as a professional basketball player, either in the international or U.S. market in the fall of this year. I think my assistant emailed everybody a copy of that letter along with some other stuff. I have counseled with DeMarcus extensively. He has filled out a plea acknowledgement sheet that I got him to fill out. He's also got him to sign a letter advising him of what he was charged with, the potential and maximum punishments, as well as first offender plea. I've also advised him that he can't possess a firearm during the pendency of his, until his sentence is terminated. And if he successfully completes it, then he won't be able to have he won't have a felony conviction. The big issue, Judge, that we're asking the court is to accept the NOLO plea, and specifically, if the court will do that, to allow DeMarcus to travel for his employment. I know a lot of times probationers either have to get permission or can't travel at all outside of the state, much less the country. So we're asking for the court to, he's had one bite at the apple, and we're asking the court to allow him that one bite and get his life on the right course and put this behind him. And he's ready to go talk to whoever y'all want him to go talk to about how this has affected him, how to avoid it, and to move forward. So I don't know, I haven't asked him how exactly when he can pay the restitution. Do you know how soon that can be paid? A week or so, 10 days? A month, 30 days, they're saying?
Who else is in the room? You seem to be looking at someone else for an answer.
Mother, Judge. Who was one of my team moms for my football teams as well. So, and his dad, his mother is deceased. He has a stepbrother who's playing football at Florida State, and his father was also helped me coach, but he's working today. They just a blue collar, hardworking family, Judge, and he just did something stupid, quite frankly, and he understands that, and now he's paying for it. And hopefully this will be the last time you see or hear from him, other than on television.
Sure, the bright lights of the NBA or the who knows what league. Okay, well, I have a few questions of your client. Mr. Simons, you do take medication for the bipolar diagnosis?
Yes.
How often?
Well, I would originally take it every morning, but since Corona, I haven't really had as much of a chance to go to the doctor and stuff. But so once this is fine, I'll be able to take it every day again.
When was the last time you had the medication?
Probably the last time I had the medication, probably in March.
Okay. So you just haven't gone to see a doctor since then?
I haven't gone to see the doctor in Atlanta since.
Okay. Does the fact that you have not had the medication for 4 months now make it in any way difficult for you to understand what we're talking about?
No, sir.
Were you taking the medication in August of last year?
Yes.
So you had been diagnosed and prescribed before you and Ms. Schenk had whatever relationship you had?
Yes, sir. But
Okay.
I had moved to Miami and I wasn't able to get medicated for a while because of the professional basketball stuff. I wasn't able to see a doctor. And once I moved back to Georgia from Miami to get my medicine again, it literally happened all in that area.
Time frame.
Area meaning time frame? So how long had you been off the medication before this incident happened?
I'm not sure, maybe around 5 months.
And how long had you been taking it before, how long after you had started back taking it before this incident happened?
My entire college career, so since.
No, if he's talking-
I didn't ask the question well. You told me you went to Miami, you hadn't been taking it for a while, then you came back here, and all around about the same time you got back on the meds, you and Ms. Shank had this disagreement and this situation happened. How long had you been taking the medication again before this happened?
About 2 weeks.
2 weeks, okay. And Ms. Shank is someone you met at Georgia State?
Yes.
How long had you all been in a relationship before this happened?
I literally met Brooke approximately a year and 2 months before all of this happened.
Mr. Lancaster, you mentioned something about a plea sheet that you filled out. Is that something that you can get filed?
I can. We're not through filling it all out with regard to the maximum minute and the sentencing, but we got it from your office. And it's 1, 2, 3, 4 pages. I had him fill out one of my own that doesn't have everything that yours has on it. And, so he was filling that out as well when we started.
Okay, well, either one, if you sign it and Mr. Simon sign it, I'd like you to get that to Ms. Nelson so that she can get it filed and made part of the record, okay?
I can have my office send you what he's already signed from out right now and see if that's sufficient.
It will be sufficient. If you'll
Yeah.
just have your office send it to Ms. Nelson, you've got her email address, then she'll get it filed.
So send that to Ms. Nelson immediately.
Mr. Simons, I know you've already talked about it a little bit with Ms. Hall, but I need to cover it with you as well. You are asking to be treated as a first offender, which is something you qualify for. There's no evidence that you've had a felony conviction since you've been an adult, which under Georgia law, you've been for 5 years now. So you're eligible for first offender treatment. The main benefit of first offender is that this is not a conviction. I understand it's a NOLO plea, but in addition to being a NOLO plea, it's not a conviction. So if anyone asks you, are you a convicted felon, or even are you under sentence as a felon, the answer is no, as long as you remain in good standing. And at the end of your sentence, if everything goes smoothly for you, then it won't be a conviction, NOLO or otherwise, because at the end of a first offender sentence, the slate is wiped clean. It's your, as your lawyer put it, your one bite at the apple. It's not an apple you want to bite anymore, but that's it. So the good side is that these charges effectively go away if you successfully complete your sentence. The downside is that if while you are on your first offender probation, you catch new charges, then not only do you have your new case to work with, but because you've already entered a plea in this case, NOLO or otherwise, you'd come back in front of me, sort of like a probation revocation. And if the state was able to demonstrate to me that you in fact did the new case, whatever those charges are, I could resentence you in this case without a trial, because you've already entered your plea. I could resentence you up to the maximum. Now the state's reduced count 1, so that's forever a misdemeanor, but it would mean that I'd have 21 years to work with, 20 for the ag assault and then 12 months for the misdemeanor. I'm not suggesting that that would be the likely outcome, but just as a hypothetical, if you got into a physical altercation with a new girlfriend next year and you broke her jaw, and the state was able to demonstrate to me that that's what happened, I would likely resentence you and you'd go to prison for a while. And I'd have 20 years to work with on that. So you need to understand the downside. If you feel like you are in a good situation now and the medication helps and the family support, et cetera, then choosing first offender may make lots of sense. I don't decide that for you. You and Mr. Lancaster, I trust, have talked about it, but I need you to tell me that you understand the benefit of first offender as well as the risk of first offender. Do you understand that? Understanding it, do you want to be sentenced as a first offender?
Yes, I do.
Okay. Home, where do you live right now? I don't need a street address, but are you in the metro Atlanta area?
Buford, Georgia.
Buford?
Buford, Georgia, Gwinnett County.
Okay. So your probation will be supervised initially out of Gwinnett County. And I'm addressing Mr. Lancaster's question about travel. We're going to defer dealing with that. I'm not opposed to letting you pursue the opportunities that are out there for you. But let's wait to see what happens. Unless and until you need to routinely leave the state or leave the country, we're not going to worry about it. But I will get involved. If you are able to document a professional need to travel, then I can authorize probation to let you do that so that you don't have to come back each time. So if we pretend you were on the Hawks, you wouldn't have to, before each game, well, now we're going to Vancouver, now we're going to Boston, they're all down in Orlando anyway, but wherever it is you'd be going, we would just give you blanket permission to travel. But you're not doing that now. Similarly, you might get into the Italian league and then you'd be moving to Italy. We'll work through that if and when that occurs. But it sounds like for now, you live in Gwinnett and you are not traveling all over the place. Is that correct?
Yes.
Okay. Do understand this. If you need to leave the state of Georgia, you need to get permission in advance from your probation officer.
Yes.
And they ought to give it if you're doing well, if you're doing the things you've committed to do. But when I'll plug back in is if you develop a situation where you know, like, I'm going to have to leave the state all the time now because of basketball, because of whatever. But until then, you're going to stay local and you'll be supervised out of Gwinnett. Does that make sense?
Yes, it does.
Mr. Lancaster, do you have any questions about that?
I do not about that. I did forget to ask some other things, but we'll get to it when you get done with Mr. Simons.
Okay. Do you have in mind, Mr. Simons, a way in which you'd be able to give back to the community in the way Ms. Hall has described? I love the idea. You're someone that incoming students would pay attention to, and what you almost threw away because of what happened with Ms. Shank is probably a good lesson for folks. But I don't want to just leave it hanging out there that, well, someday you're going to give a speech to someone. I had the good fortune of being involved a little peripherally with the prosecution of T.I. You know T.I.
Yes.
His situation was a whole lot more serious than yours. And he committed to, it was a very large number. It was hundreds of hours of community. He spoke at schools, he did this and that. That's not your situation. But his lawyers had mapped it out. They actually, that was their sales pitch because he was looking at a few years in federal prison. But it's the same mold. You're someone that, whether it's high schoolers or college students, they would listen to. And I think you could have a positive impact on them. But we need some shape to it, whether it's, look, you're going to give at least 5 speeches at local Gwinnett high schools, or, I mean, people aren't going to be going to assembly anytime soon. That's the other part, is that it might be a virtual presentation. But I want to make sure it's something you can end up doing so there's an impact. Is it something you've thought about, Mr. Simons, or you just knew the state was going to ask for it?
Well, that's both, Judge. I've discussed it with Ms. Hall. We didn't really come up with a particular number. I think she suggested like three events. And I'm just basing it off of my recollection. I could be totally wrong, but we didn't know. We started off talking about him going to like incoming college classes, and then the COVID hit, and then it just kind of got left behind. So like I said at the beginning, we're willing to do whatever we can do, but I don't think we can just call up the school and say, hey.
Right. Ms. Hall, do you have any thoughts about how you make something like this happen?
No, Your Honor. I was, when you gave me a chance to speak, I was going to clarify on that because I did hear Mr. Lancaster's, say wherever we wanted them to go. Our intention was just like any other program. They found it, just a couple classes. Because we feel as though this case was very serious, but we understood that Mr. Simons had a lot going on in his life as well, negative and positive at the time. So we felt as though this is just a good way to end this case. I didn't look into it, contact any schools. Now with COVID going on, people are doing a lot of virtual things. I'm sure if the school already have something like that set up for their students, they wouldn't mind just making a session for him if because we all have to get back to some type of normal life at some point, as much as we can. So no, I hadn't thought about it. I hadn't even intended to, but I can see if we have anything. Someone else has sent anyone to any type of virtual program to something similar to this. If you need me to, I will. I don't mind.
All right. I think I have a way we can make this work. I just wanted to see if anyone had any specifics. I think those are the questions I had of you, Mr. Simons. Mr. Lancaster, you had some questions. Should we deal with those now before I talk about accepting the plea?
I had also talked with Ms. Hall, and she said that this would be up to you. Of course, I agree with that. Everything's up to you. But we had also talked about, and I think that Cheryl has emailed Ms. Nelson a motion for an order limiting public access and sealing the court records while he's on first offender probation. And also a proposed order granting that motion. So that we would also be asking for that. If the court accepts the plea, then we're also asking the court to limit public access. And I can file that motion. I didn't think it was appropriate to file it until he was sentenced, but we went ahead and emailed the motion to your office along with the proposed order.
Sure, you should file the motion. I did see it. I will look at it. Ms. Hall, do you oppose it?
I do not, Your Honor.
I understand why you'd want to do that. I just need to make sure we craft it narrowly. Some lawyers have recently said we want to limit access, and then no one can get in there, and that's a problem for probation and the clerk's office if they need to look at the case file or if they need to file something in the case, good or bad. So you've said it carefully, and I like the way you said it, Mr. Lancaster, which is it's the public access. So someone just nosing around running queries based on names in the news would not find something for Mr. Simons. But if the clerk's office or probation needed to look at the file or put something in the file, they'd be able to do that. I'm not opposed to that kind of language. So you file your motion and I'll take a look at the proposed order and we'll see.
I'll have Cheryl email the proposed order in a Word format to Ms. Nelson. That way you can cut and paste. Or
great. Did you have anything else?
I can't think of anything else.
Okay.
You still want me to finish filling out his plea sheet that I got from Ms. Nelson?
No, if you completed the one you already had, that one will be sufficient.
Okay. If you need it, you let me know and I'll take care of it.
Okay. So Mr. Simons, I find there's a factual basis for your plea. I appreciate it's a NOLO plea and why it's a NOLO plea, but it does sound to me that if this went to trial, the state would be able to demonstrate through the testimony of Ms. Shank and certain medical professionals that this happened. I also find that your plea is knowing and voluntary. Knowing means you've understood all the things we've talked about, and if you didn't, or if your lawyer didn't, then we've explored that. Is that a fair statement?
Yes.
Voluntary means exactly what you think it does. No one's forcing you to enter this plea, but you're doing it of your own free will because you've decided this is the right way forward for you. Is that correct?
Yes.
Then I'm accepting your plea. I'm sentencing you pursuant to the Probation Options Management Act. And what that means, Mr. Simons, is that while you are on probation, if you have a technical violation, maybe you miss a meeting or there's something you're supposed to do that's relatively minor and you don't do it, you and probation will work that out. That doesn't come back to me. But if it's something more serious, you get arrested, you have new charges, that comes back to me for my consideration as to what the consequences should be. I am going to sentence you as a first offender in this NOLO plea. Your sentence as to count 1, which has been reduced to battery, is 12 months to serve, but I will probate those 12 months. Your sentence as to count 2 has to be at least 3 years, but I can probate or suspend any of that. And it will be 2 years probation followed by 1 year suspended. It will run concurrently with count 1. So the overall sentence is 2 years probation followed by 1 year suspended. Suspended means what it sounds like. You're not being supervised. There are no travel restrictions, nothing like that. But it does mean that if you were to do something against the law during that 3rd year, even though no one's supervising you, you don't have to report to anyone, the state in theory could seek to revoke some part of that year. Special conditions of your probation. Number 1, you're going to pay $730 in restitution to Ms. Shank. You will not pay that to her directly. You do not need to pay it all day one. We don't have a debtor's prison. You'll pay it as you are able, but you do need to pay it. You'll pay it to probation. They'll get it to Ms. Shank. Ms. Hall, you didn't say anything about no contact with Ms. Shank. Any reason I should not make that a condition?
No, Your Honor, I just forgot about it. Sorry.
That's okay. You were being swept away by a hurricane. Mr. Lancaster, is there continued contact between your client and Ms. Shank, or is it appropriate just to keep things safe and separate that a condition be that Mr. Simons have no contact with her?
I've advised him not to have any contact with her, but I think she's made several attempts to try to contact Mr. Simons either directly or through his stepmother. So have you had any contact with her? He hasn't spoken with her, so.
So I'm going to make it a condition, but let me explain a couple things, Mr. Simons. It's not a trap. So Ms. Shank sending you a text doesn't mean you've contacted her. You responding to the text would be a bad choice. So you just leave her alone. If for some reason it becomes so important for her to have you back in her life, she can talk to the prosecutor, and the prosecutor can talk to Mr. Lancaster, and the two of them can come to me saying, we'd like to modify the sentence because Ms. Shank wants to be able to spend time with Mr. Simons, and frankly, he wants that as well. And if I'm convinced that that's a safe and good idea, then I'll modify the terms of your probation. But the right path for you is to not call her or write her or text her or do anything social media related to Ms. Shank. And similarly, not to have anyone who's close to you do that. No friends, don't have your family reach out to Ms. Shank. If she is trying to reach you, you need to let Mr. Lancaster know so he can tell Ms. Hall, and Ms. Hall or someone working with Ms. Hall will reach out to Ms. Shank saying, you need to stop that because Mr. Simons is doing his own thing right now. So special condition number 2 is no contact, direct or indirect, with Ms. Shank. Special condition number 3 is that you take all medication as prescribed by any medical professional. So I appreciate that it's COVID, but that doesn't mean you can't see a doctor. It doesn't mean you can't get your prescription filled. I just want to make sure you're getting the help you need so that you don't have another situation like this. So if a doctor has said, Mr. Simons, you take medication X, you need to be taking it while you're on probation. And if it's something that makes you feel weird, you go talk to the doctor and say, I need a different prescription. But it does sound like you would benefit from being on certain medications. And then special condition number 4 is you will complete either 120 hours of community service, or you will have at least 5 speaking engagements with high school students or college students to share with them the sort of lessons you've learned about bad decisions and getting involved with the criminal justice system, and how these folks might want to do things a little differently to stay on the straight and narrow when they're facing some of the kinds of pressures you were as a student athlete. I leave it up to you and those who support you, Mr. Simons, to identify those speaking opportunities. And I don't mean a one-on-one that you talk to this one basketball player from a high school, but it would be talking to a team or a class. And if you document 5 of those to probation, that can be in lieu of the 120 hours community service. If you choose not to line that up, or you take sort of a go easy approach on that, you will have these hours of community service that you need to take care of that you can do in any way. You could be a coach in a rec league, and if you're volunteering and that's deemed to be community service, there are hours. It could be the default that a lot of people think of, which is picking up trash on the side of the road. I think that's a waste of your talents, but you and your probation officer will work through how you're going to get those hours. But again, you don't need to do the 120 if you're taking care of speaking engagements. But I'm going to put the obligation on you and your team to identify which route you're going to take. Any questions about that, Mr. Lancaster?
No, Your Honor.
Ms. Hall?
Nothing from the state, Your Honor.
Okay. Mr. Simons, I wish you the best. I've got the indictment here. You, in theory, would sign the indictment if you were in court, but you're there with your lawyer, as you ought to be. Do you authorize me to sign the NOLO plea in your indictment, Mr. Simons?
Yes.
Mr. Lancaster, you'd sign it as well. Do you authorize me to sign on your behalf?
I do, Your Honor.
And Ms. Hall?
Yes, Your Honor.
Great. I will sign for the 3 of you. I'll get with Ms. Nelson about how to indicate that count 1 was reduced. And I've already indicated that it's a NOLO. I think the last thing is that Ms. Crawford needs to give you some reporting instructions, Mr. Simons. I think that you actually will start out in Fulton County because that's where this case occurred. And so when you report in the next 72 hours or whenever it is, you're going to go to their office on Memorial Drive. But when you give them your address, they'll say, look at that, Beaufort, Gwinnett County. And so the folks in Fulton will tell you where to go in Gwinnett, and your officer who will be working with you will be based out of Gwinnett. Am I kind of right about that, Ms. Crawford?
Judge, I'm gonna have him to report to Gwinnett County for his first report.
Well, there you go. I'm wrong about that. Normally she makes me say to you, you're going to go to Fulton, but just for today, apparently you get to go to Gwinnett. Do you have that information for Mr. Simons?
Yes, I do. And I need to get an address and emergency contact from him also.
Okay, I'll let you guys do that in just a second. Ms. Hall, anything else in Mr. Simons's case?
Nothing else from the state, Your Honor.
Mr. Lancaster, anything else?
No, Your Honor.
Okay, then we'll go off the record. Thank you, Mr. Forte. And then you guys can stay on, Ms. Crawford and Mr. Simons. Mr. Simons, you're going to get some information to Ms. Crawford, so she's got contact info for you, and then she'll give you info about where you need